series. Today's session is on the release of ethics documents under the Freedom of Information Act, the Privacy Act, and the Ethics in Government Act. As mentioned, my name is Jennifer Mattis. I'm an attorney with the Program Counsel Division at OGE, and I'm really excited to welcome two excellent attorneys from the Department of Justice's Office of Information Policy to talk to you about the Freedom of Information Act and the Privacy Act. We have Bobby Talibian, Chief of the FOIA Compliance Staff at OIP. His team assists OIP in its responsibilities to oversee and encourage government-wide compliance with the FOIA. In addition to serving as an instructor for FOIA training programs, he provides legal advice on the FOIA to various federal agencies and is OIP's subject matter expert for Exemption 4 and reverse FOIA lawsuits. And here's Lindsay Roberts, an attorney advisor with OIP. Her responsibilities include providing guidance to DOJ components and other federal agencies on FOIA issues, including reporting and regulatory requirements. In addition to serving as an instructor for various FOIA training programs, she is OIP's subject matter expert for FOIA Privacy Act Interface and FOIA Exemption 6. Before I turn things over, I just want to briefly let you know why we thought this session would be useful. As OGE's alternate FOIA officer and one of our Privacy Act experts, I often receive questions from inside our agency and also from ethics officials regarding the release of ethics documents. And in my experience, these questions rarely implicate just the FOIA or just the Privacy Act. Rather, untangling the issues usually requires at least some understanding of all three of these laws. So that's why we thought it would be useful to discuss all three in one session. So with that, I'll turn things over to Bobby and Lindsay to discuss the Freedom of Information Act and the Privacy Act respectively. And then when they're done, I'll take a couple of minutes to go over some relevant Ethics in Government Act provisions. Thank you.
Thank you, Jennifer. I'm very excited to be here. And this was a really great idea on Jennifer's part to really for us to just take a brief moment to discuss all the three laws that involve disclosure of ethic records. So I was going to start off with the FOIA, and I know we have a question and answer period at the end of this, but I also just invite, if there's any FOIA questions at any time and after this session, I invite you to also call OIP's FOIA Counselor Service line at 202-514-FOIA. But with that, I will start off with the FOIA, hand it over to my colleague Lindsay for the Privacy Act and the Privacy Act FOIA interface, and then we'll go to Jennifer with the Ethics in Government Act. So starting with the first slide, the FOIA pertains to federal agency records that exist and can be located in agency files. These are records that are created or obtained by an agency and are under the control of the agency at the time of the FOIA request. For control, we look at four factors: the intent of the document creator to retain control, the ability of the agency to dispose of the record as it sees fit, the extent of the agency has relied on the records, and the degree that the records have been integrated into the agency's files or systems. With those factors in mind, I would say that the vast majority of records that are found in agency files are agency records that are subject to the FOIA. Often what typically would not be an agency record would be a personal record. For example, if for some reason my grocery list for the day was in the files for some reason in my office, those would not typically be, that would not be a agency record. That's more of a personal record. And then also congressional records. The Supreme Court has highlighted the basic purpose of the FOIA, but the basic purpose of the FOIA is the allowing it for a informed citizenry. The FOIA allows any person the right, gives any person the right to request agency records from the government. And the government in turn has an obligation to release all portions of those records unless they are protected by one of 9 exemptions that protect important interests. On his first full day in office, President Obama highlighted the importance of government transparency, the Freedom of Information Act, and ethics as means for government accountability. So I think President Obama's first day was a very exciting time for both of our offices. For FOIA, the president issued a memorandum on the FOIA directing a new policy of a presumption of openness, where in doubt, openness should prevail. The president directed the Department of Justice to issue new FOIA guidelines to agencies on their implementation of the law. And in March of that year, in 2009, the Department of Justice issued its FOIA guidelines to agencies. And one of the things that we have in the guidelines is a foreseeable harm standard, where we encourage agencies to make discretionary releases of information when there is no foreseeable harm in that disclosure of the information, and not to withhold information when simply because an exemption applies. And we'll get more into that as we talk about exemptions, but I wanted to highlight that from the president's memo and the AG's FOIA guidelines. So as I said, the FOIA requires an agency disclose all material that have been requested unless portions of that material are protected by one of the interests that are in one of the 9 exemptions that are specifically exempted from the disclosure provisions of the FOIA. For context, across the government, pretty consistently, Exemption 6 and 7C and Exemption 7E are the most frequently cited exemptions for withholding information. Exemption 6 and 7C are the personal privacy exemptions. So here agencies are protecting unwarranted invasions of an individual's personal privacy. Exemption 7E is the law enforcement's and techniques and procedures. And then this can change from year to year. The next exemption that last year was the 4th exemption was Exemption 5, which protects the civil discovery privileges. But for today, we thought we'd focus on the exemptions that the Office of Government Ethics specifically cites to. And looking at the Office of Government Ethics annual FOIA reports, we know that not only are these the most cited, but they were the only cited exemptions. So there are Exemption 6, which is the personal privacy exemption, Exemption 5, the civil discovery privileges, and Exemption 3. And I'd like to unwrap those a little bit, since those are typically the exemptions one would consider when looking at the ethics records. So when considering ethics records, there are many types of records, some not too unique to just ethics, but some that are unique to ethics, where we may be examining these records for exemption applicability and disclosure determinations. Financial disclosure forms, those are the Form 450s and is it 278? Yes, thank you. Form 278s. Any records related to that, agencies may form recusal lists, ethics advice and counsel that's been given, waivers and approvals of conflicts of interest, training records, reports and questionnaires, any referrals to the Department of Justice. These are all the types of records that we'll want to consider as we're considering the exemptions. And as we go through each of the different statutes that we're talking about have a certain role in how this information gets disclosed. So starting with Exemption 3, we're going to take them in chronological order. So starting with Exemption 3, Exemption 3 protects information that has been specifically exempted from disclosure by another statute. So the first thing we want to look to when considering an Exemption 3 use is whether the statute we're relying on is a proper 3 exemption statute in the first place. A statute is a proper Exemption 3 statute if it either absolutely prohibits disclosure of specific information with no discretion to the agency, or if it provides discretion, it limits that to to either establish criteria or by referring to particular matters that are to be withheld. Also, through the amendments to the FOIA, any statutes that have been enacted after October 28, 2009 must also specifically point to Exemption 3 of the FOIA in order to be a proper Exemption 3 statute. The Department of Justice provides resources to help agencies determine whether a Exemption 3 statute is a proper Exemption 3 statute. And one of those resources is our approved Exemption 3 list, which is really a list of Exemption 3 statutes that the courts have found to qualify as Exemption 3 provisions. It's obviously not an all-inclusive list because there could be provisions that have not reached the courts and that very well could be proper. We also have a separate list of Exemption 3 statutes that we put out every year, citing all the Exemption 3 statutes that agencies have cited in their annual FOIA reports. So those are good two resources to look to when trying to determine whether Exemption 3 statute is a proper Exemption 3 statute to use. For ethics, we have the Ethics in Government Act, which has provisions that have been qualified to be Exemption 3 statutes, to be an Exemption 3 statute. For those confidential 450 forms, Exemption 3 should be cited to withhold those forms under the Exemption 3 of the FOIA under 5 U.S.C. 107A. And any portions of those forms that are transferred into another record. So if you have a recusal list and you've taken information from the 450 form and you've just transferred it over to another form, Exemption 3 would still apply. It's not specific just to the form. The 278 forms, while there is a public access avenue through the statute itself, FOIA is not the proper avenue for accessing those records. So there's an Exemption 3 would be cited in the FOIA context. But as I'm sure Jennifer will get into, as a matter of good customer service I'd always encourage anyone who's citing Exemption 3 for those types of forms to explain to the requester how they can properly access those records. And then for the conflict of interest waiver determinations, we bullet here for 18 U.S.C. 208 D1. The conflict of interest waiver determinations themselves are something that is publicly releasable. However, courts have found that any information that's been put into those that go beyond what is required in the 450, it can be withheld. One example from I don't know how you pronounce this, but I look at it at the Sefi case, which is cited there, was a designation of family members designating which financial interests belong to them. And while the form allowed for that, the court found that it wasn't a required thing. So since it was not required by the 450, that was something that was withheld. Another example, the courts have also said that anything that can be withheld under FOIA can be protected on these records as well. So Exemption 6 may be something to consider on a case-by-case basis for these records. Exemption 5 of the FOIA is our next exemption that we want to look at for ethics records. And the language of Exemption 5 says that agencies can protect they can protect interagency or intra-agency memorandums or letters which would not be available by law to a party other than an agency in litigation with the agency. I don't know about you, but when I first looked at that, I had no idea what that meant. But what that convoluted language really means is that information that meets both the intra-agency threshold and is covered by a civil discovery privilege can be protected under Exemption 5 of the FOIA. Exemption 5 protects the civil discovery privileges. While Exemption 3 may not be a good candidate for a discretionary release because you have a statute that bars disclosure, so there is no discretion, under Exemption 5, especially with deliberative process information, there could be very good candidates for discretionaries. And so these are where we would encourage your looking at these records, not only for the applicability of the exemption, but to see if there is a foreseeable harm in disclosure. So as I said, the first requirement for Exemption 5 to apply to records is a threshold requirement that the records be inter or intra-agency records. And here what this means is that the records created by the federal agency stay within the agency or amongst the federal agencies. It's not shared with the outside. However, there is an exception to this, which makes a lot of sense. Courts early on recognized that, like any other organization, federal government agencies have the need to consult with outside parties to effectuate their missions. So we have a doctrine of the consultant corollary. And so as a consultant, when agencies are seeking or given neutral advice on a topic, that information can still meet the threshold requirement. In determining whether the consultant corollary is met, some courts have looked to see if it is neutral advice not given at the expense of another party. There's been some mix on how much weight is given to that. What's been very, I think, strongly looked at is whether the consultant or the person is in any way adversarial to the agency. And in that situation, the consultant corollary, which makes sense, would not be applicable. Here, what's kind of the best analogy is that the consultant, while not a federal agency employee, not the federal government, is really acting as if they were, akin to that, and really providing consultant services to the federal government. So if the threshold requirement of Exemption 5 is met, the next requirement is that one of the civil discovery privileges, one of the recognized discovery privileges, must apply. And any of the civil discovery privileges can be protected under Exemption 5. However, there are by far 3 privileges that the government looks to and cites to most often than any other privilege. And those are the deliberative process privilege, the attorney work product privilege, and the attorney-client privilege. And so I'll highlight those briefly today. The deliberative process privilege really protects or provides protection for the decision-making process of agencies. It encourages open and frank discussion within the agency in order to enhance the quality of an agency's decision-making. And so there are 2 requirements for the deliberative process. First, the information must be pre-decisional, so it must be antecedent to a final decision. Typically, anything that is leading up to a final decision, discussion-wise, any discussions that are in the process leading up to a final decision will be pre-decisional. There are factors that you can look at. You can look to see who is the document creator, for what purpose are they creating the document, is it going to a subsequent, is it a subordinate going to a supervisor? Those factors can help decide if it's pre-decisional, but they're not determinative, because even a person in a supervisor or decision-making role can have deliberative information that's pre-decisional, right? If I am a decision maker, I have a thought process in making my decision, the final decision, and that thought process would still be pre-decisional. In addition to being pre-decisional, the information must be deliberative. Again, this privilege is protecting the decision-making process. So things like recommendations, discussions, discourse, opinions, and so forth, these are things that would be protected under the deliberative process privilege. What typically is not protected are factual information, because they have nothing, typically will not have anything to do with the actual deliberative process. Unless the factual information itself is so intertwined in the deliberative process that there's no way that you can remove it without revealing deliberative information. This is typically where I'd ask for any other questions, but we'll save those for the end. So the other discovery privileges, the attorney work product privilege and the attorney-client privilege. The attorney work product privilege protects any information prepared by attorney under the attorney's direction in reasonable anticipation of litigation. Litigation does not have to commence, and litigation does not have to be civil or criminal. It can be civil, criminal, or administrative proceeding. But really what you're looking for here is being able to articulate that the information was prepared in anticipation of a reasonable claim that could have arisen. For the attorney work product privilege, facts can be protected as well. That is part of the attorney's work product. And also there's no temporal limit. So there's no time limit that would diminish the attorney work product privilege. The attorney-client privilege, it protects communications from a client to an attorney. These are communications when a client seeks the advice of the attorney. So the factual information actually that the client provides to the attorney can be protected. And then the legal advice given by the client to the attorney. In agency situations, this is often a situation where the agency is going to the Office of General Counsel for a legal opinion. So for applying Exemption 5 to ethic records, some of the records we may want to consider are emails, memoranda, recommendations, notes, and approvals related to ethics analyses and waiver requests. Emails are just another platform for how records can be created, but often we have candid and discussions on email trying to determine a final decision or trying to determine a recommendation, and so emails can often contain deliberative information or work product or attorney-client. Really, it's not the email that's the determinative factor, but just a place where that type of information can be contained. Same for memos. Recommendations and notes typically are deliberative by nature. Ethics guidance, opinions, and advice typically releasable, but depending on, so any guidance, for example, the way OIP gives guidance for FOIA matters, any ethics guidance on how ethics rules should be interpreted, those types of guidance from the Office of Government Ethics, OGE, would be releasable and should be released. Ethics programs and training materials, same for that as you can see for FOIA, all of OIP's training material, we post those online. Those are fully releasable. Ethics related policies, final agency opinions and policies are not only things that should be released, are things that we have proactive disclosure obligations as well for some of those. And referrals to the Department of Justice may depend on what is part of those records that are being referred to the Department of Justice. But B5 could certainly, for work product and for deliver process, could certainly be something that be considered. So the third and final exemption that I was going to go over today is Exemption 6 of the FOIA. And Exemption 6 protects individual personal privacy. It's one of two exemptions in the FOIA that provides us protection. The other exemption, 7C, pertains specifically for law enforcement records where personal privacy can be implicated. But the language of Exemption 6 says that we can protect information in personal and medical files and similar files when disclosure would constitute a clearly unwarranted invasion of personal privacy. So there are two things really to unpack here. First is a threshold requirement, which is that the information be in personnel and medical files and similar files. And then is the other standard that disclosure would constitute a clearly unwarranted invasion of personal privacy. So looking at the threshold, personal and medical files are pretty straightforward, and we all know what those are. So the question really is, what does similar files mean? When thankfully the similar files has been given a very easy and a broad interpretation. And generally, any information that can be linked to a person would fall under the threshold of Exemption 6. The Supreme Court, when they looked at this, said that that it would be unreasonable to assume that Congress thought that the labeling of a file could dictate when Exemption 6 should apply and when it shouldn't, when we should protect these privacies and when we shouldn't. And I think, to me, that makes a lot of sense. And it can be, it's not just paper records. We have case law that has Exemption 6 applied to audio records. So it could be in any file or format. So living individuals generally have a privacy interest in not having agencies disseminate personal information about them. So once we identify that we have the threshold of Exemption 6 met, meaning that there is a link to a person, this is information that can be linked to someone, we then want to identify whether there is a privacy interest. And this is really going to help us, this next part of the analysis is going to help us understand if releasing information would cause a unwarranted invasion of personal privacy. So first we want to identify if there is a privacy interest. And as I said, this is sometimes not what someone would think of a privacy interest would be. So it's not just limited to intimate or personal details or what someone might find personally to be embarrassing if released. Really here, we're looking at the person's interest of maintaining control over information about themselves. So living individuals have a privacy interest in not having that type of information personal to them released or not having that control over it. So there's been privacy interest that has definitely been found in the person's name, address, phone number, date of birth, criminal history, medical history, social security numbers. And before we get into a little bit more of that, I wanted to highlight this GLOMAR response. So sometimes we may get a request that's so targeted that it's not just the information in the records, the release of and protection of might implicate a privacy interest. It's even acknowledging that that record exists. A pretty good example is if for some reason, and I hope, I know this is not to be the case, the FBI is investigating me. And Lindsay, for some reason, has an interest in making a request to the FBI, and I want all records on Bobby Talibian. And the FBI has not acknowledged, and no one knows that I'm being investigated publicly, and there's no public acknowledgement of it. So just the fact of whether there exists a record with the FBI, yes or no, that in itself would invade my personal privacy. So the FBI would then say we can neither confirm nor deny that there is an investigative file on Bobby Talibian. When a similar experience, a similar situation might arise with ethics records, whether someone's being investigated or looked into for an ethics violation. And if the request is specifically targeted in a way for looking for that, and there's nothing that's been acknowledged by the agency for that individual, that agency would want to GLOMAR the response to the third party.
Excuse me. Just an FYI, one place where this might come up with ethics records would be in the Stock Act post-employment negotiation letters that are required. That might be a situation, in some circumstances, it would be appropriate to GLOMARize.
Yes, thank you. Yes, perfect. Yeah, I said going back to the other side, living individuals have a significant privacy interest. For deceased individuals, that privacy interest is diminished. And so agencies have not been courts have not been very clear on what reasonable steps agency should do to determine the life status of a person, to determine if the privacy interest has been diminished. But one of the things that has been upheld is the FBI's 100-year rule. If it's not known, basically that anyone based on their birth date who is over 100 years old is presumed to have a diminished privacy interest, unless we know they're not deceased. So another group that has diminished privacy interests are federal civilian employees who do not have sensitive occupations, as in law enforcement, in not personal details about themselves, but in details about their work in the federal government and their qualifications for the job that they're conducting for the government. There is an OPM regulation that directs agents that actually has a list of certain items that agencies should be releasing about federal civilian employees, and that includes name, present and past position titles and occupational series, present and past grades, present and past annual salary rates, including performance awards and bonuses, present and past duty stations and position descriptions, job elements, and performance standards. It's a diminished privacy interest in what we do in our employment with the government. But like I said, it does not diminish our privacy interest of more personal matters. For example, what health insurance I picked, what days I've taken off, where I've gone for vacation, so forth and so on. So if we've identified a privacy interest at play, the next question would be if there is a FOIA public interest. And FOIA public interest may not be what one would think of it at first glance either. It's not I like to say, like a tabloid public interest, not the general public's interest. It is the FOIA public interest is directly related to the core purpose of the FOIA, which is to shed light on agency actions and activities in their performance of their statutory missions. So FOIA public interest is limited to anything that would shed light on agencies' activities. When considering if there is a FOIA public interest, the identity of the requester or the reason that they need that information, particularly if it's for personal needs, are not factors. what we're really looking at here is by disclosure of these records, we can shed light on the agency's performance of its statutory mission. So it's really the agency's action that's the FOIA public interest. I think I skipped a side. There we go. So if we have a significant privacy interest, we then look to see if there is a FOIA public interest. And if we have a FOIA public interest, we have to balance those interests. So the way I like to look at this is, for exemption 6 is a four-step process. First, if you recall going back, we need to satisfy that threshold requirement, which is most often easily done if the information is going to be linked to a person. Once we satisfy the threshold requirement, we identify if there's a privacy interest. And if there is a significant privacy interest, meaning anything more than a de minimis privacy interest, then we need to go see if there is a FOIA public interest. If there's no privacy interest, the information should be released. If there is a substantial privacy interest, then we look to see FOIA public interest. If there's no FOIA public interest can be identified, then to protect the privacy interest, we withhold that information under Exemption 6. If there is a FOIA public interest as well, then we have to balance the two and determine which one outweighs the other. So some things to consider when balancing, some factors. Information concerning to intimate details of a person's life would generally deserve protection, or they would have a very significant privacy interest. The passage of time for Exemption 6 not only does not diminish the privacy interest, in many instances can elevate it, can make it more significant, particularly when we're talking about things like someone's criminal or some kind of misconduct history. Let's say 20 years ago, I was convicted of some kind of a crime, without disparaging myself too much. I rehabilitated myself. I've become a good citizen. I'm now working for the federal government. I'm doing great public service. Even though that may have once been in the court's public files, and if you really looked hard, you could find it, it's practically obscured. And so my privacy interest is not only diminished, it's increased now, because bringing that back to light would significantly invade my privacy, and there would be potentially very little FOIA public interest in doing so. One thing you should also consider is there's adverse consequences for the person if their information is disclosed. That could also elevate the privacy interest. Proven allegations of official misconduct could constitute a significant public interest. So for official misconduct, it depends on two factors: the level of the person where the misconduct is applying to, and also what the misconduct is. So the more serious and intentional the misconduct, and the higher the level of the official, the higher the public interest. And the lower level of the official, the federal employee, and the less serious the misconduct. For example, if I'm taking long lunch breaks, and those types of things, the higher the privacy interest, and lower, if not any, FOIA public interest. And identities of law enforcement individuals can have significant privacy interests, which would also be protected under Exemption 7C, which we're not getting into today. So in balancing the interests, one thing we want to look to is, one approach we want to always consider is how we can maybe potentially redact the personally identifying information and still release information that would serve that FOIA public interest. Oftentimes there are ways, particularly when information is asked involving a large number of people. So for example, if one request asks for, I want to know all the prescriptions that were filled at the congressional pharmacy. And we can give them all of those prescriptions without identifying who they are. And it's a long list. No one will ever know, who was the one who's actually filling that prescription. That could be something where we can remove the privacy interest and then release information. In ethics documents, we're looking at financial and business relationships information. Oftentimes that can have significant privacy interests, but again, it can be a case-by-case balancing determination if there's a significant FOIA public interest, particularly maybe there's a conflict of interest. Family information typically would be given very high privacy protection. Things like home addresses and contact information would be protected. Social security numbers, date of birth, gifts and travel information are things that there would be more of a FOIA public interest, and so we would typically release those. Outside activities, depending on who it is and what they are, that would be more, I think, a case by case. Identities of 278 and 450 filers. The identities themselves are not something that we would protect under Exemption 6. Again, civilian federal employees have no protection, have very diminished privacy, have a diminished privacy interest in the fact that they're working for the federal government. We are the public servants in our positions, and so our identities as civilian federal employees would not be withheld. And with that, I look forward to any questions at the end of the session, but I'll hand it over to Lindsay for the FOIA Privacy Act interface.
Thanks, Bobby. Good afternoon, everyone. And in this portion of the presentation, we're going to be talking about the interface between the Freedom of Information Act and the Privacy Act. But what do I mean by interface? As we'll discuss, Privacy Act records are subject to both the Privacy Act and the FOIA. The interface comes up primarily when you have a first-party request for Privacy Act records. So that's when someone is making a request for their own records. And so it's important to understand the relationship between these two statutes, which provide separate and distinct rights of access to the individual. This helps ensure that you're properly handling the Privacy Act records. So during this portion, I'll briefly compare the FOIA and Privacy Act and provide an overview of how Privacy Act records may be disclosed under the FOIA. Let's start by a comparison with the comparison of the statutes. Congress enacted the Privacy Act in 1974, mostly because it was very concerned about how the government what information the government was collecting about individuals and how it was handling that information once it had it. So the Privacy Act was intended to protect the privacy of individuals about whom the government maintains records. And it does so in a couple of different ways. First, it limits the collection, maintenance, use, and disclosure of personally identifiable information, or PII. It regulates how agencies handle the information that they can collect, and once they have it, how they maintain that and use that information. The Privacy Act also gives individuals the right to request access to their own records. They can also seek to amend those records and request an accounting of disclosures concerning the records about themselves. And so this access right is distinct from the right that they have under the FOIA. But the general presumption of the Privacy Act is that we protect the records that are covered by it. And so if you have a Privacy Act record and you want to share it with somebody, whether that be another agency or just some member of the public, the presumption is that you're going to protect that information. You need a clearly defined reason to disclose it. And we'll talk a bit about that later in the presentation. But let's contrast that with the FOIA, which, as Bobby provided a great overview of, facilitates government transparency and accountability. The FOIA is a way for the public to know what the government is up to by allowing them to access government records. Of course, it permits agencies to protect certain records that fall within the FOIA's 9 exemptions. In contrast to the Privacy Act, where the general presumption is to protect the records, the general presumption of the FOIA is that you disclose the records unless an exemption applies. And so keeping these two different purposes in mind, it's important to really understand kind of the analysis required by each statute so that you can satisfy the purposes of both of them, of both statutes, while making your disclosure determination. The records covered by the Privacy Act must be about an individual, stored in a system of records, and accessed by personal identifier. Let's quickly define those terms. Individual, under the Privacy Act, refers to U.S. citizens or lawful permanent residents. Some agencies have expanded that definition to apply to non-U.S. persons in certain situations, but the Privacy Act itself limits it to U.S. persons. The records must be stored in a system of records. A system of records is a group of records under the control of any agency from which information is retrieved by a personal identifier. So numbers 2 and 3 kind of go together here. When basically the agency will have some compilation of records, and they locate those records using some personal identifier. So that could be somebody's name, their social security number, some unique number or account, name that is attached to that person. That's how the records are located by the agency. But an easy way to know whether or not a record is in a system of records is if it has what's called a Systems of Records Notice, or a SORN for short. This notice is something that the Privacy Act requires agencies to publish in the Federal Register whenever a system of records exists. And so the SORN provides an overview of the types of records that are contained in the system, the types of uses that the agency plans to use the information for, potential routine uses for that information, and any Privacy Act exemptions that the agency thinks will apply to that information. So if a SORN applies to a set of records, right from the start that they're Privacy Act records. And the SORNs are a great resource if you ever have questions about whether or not a certain disclosure or use of a record is appropriate. They define all of that out, and most agencies will have them posted on their websites. So that is kind of the limited, realm of Privacy Act records. The FOIA, on the other hand, covers all agency records. And so while Privacy Act records are agency records, not all agency records are Privacy Act records. The general rule of the Privacy Act is that you cannot disclose Privacy Act records without the prior written consent of the individual. So that is the baseline rule. When you have a Privacy Act record, unless you have prior written consent, you cannot disclose it. Now, there are certain conditions that may come up that would allow you to disclose it without prior written consent. And the Privacy Act in Section B lists these conditions. I'm going to cover just some of the more commonly encountered ones in today's presentation. But B1 of the Privacy Act allows you to share information within your agency on a need-to-know basis. This is what allows you to do your job, basically. That Congress did not want agencies to be hindered in actually fulfilling their mission because they couldn't share information. B2 is most important for our purposes today for this presentation, is if required under the FOIA. Now, what does this mean? If a FOIA exemption would not apply to the Privacy Act record, then you are allowed to release that record. In fact, you would be required to release it if someone is requesting it. And so a FOIA release under the FOIA is required if no FOIA exemption could potentially apply. So if no FOIA exemption applies, you release it. Now, typically, when you have Privacy Act records, Exemption 6 or 7C is going to apply because it's personal information about an individual that's generally going to be protected. But there may be circumstances where it's not. And so this is what allows us to release information under FOIA that is a Privacy Act record. And B3 allows agencies to release information or share information pursuant to a routine use that's published in the SORN. So this is why the SORNs are important, because sometimes they'll provide for things like sharing with law enforcement or sharing with news organizations or publishing information to their website. But these will be clearly defined in the SORN. So those were some of the more commonly encountered conditions of disclosure that allow you to disclose. And so now we're going to move a bit into the access rights under the Privacy Act and the FOIA. So both statutes, like I mentioned, provide separate and distinct rights for individuals to access records about themselves. However, there may be differences in the extent of access depending on the statute. Who has a right of access under each statute? Well, for the Privacy Act, that just goes back to the definition of individual. So any U.S. citizen or lawful permanent resident will have access to Privacy Act records. Now, this means that they can request access about themselves. It's the first-party requesters will have access under the Privacy Act. Under the FOIA, anyone can make an access request for any record. They can be requesting records about another person. They can be requesting records about a topic, but anyone can make an access. And so we'll talk about how this plays out in a moment. But first, I want to highlight that the Privacy Act, similar to the FOIA, has exemptions that limit access under that act. And there are 10 exemptions. I'm not going to go through them in detail, but they are listed at D5, Section J, and Section K of the Privacy Act. And these exemptions limit access under the Privacy Act, so you have a first-party requester, but the agency generally has to publish notice in the Federal Register if they will invoke the exemption. The one exception to that is D5, which is the one special exemption, which is civil attorney work product. That is like a self-invoking exemption. It does not need to be published in a SORN. But for any of the law enforcement exemptions, which is J2 or K2, or all of the other exemptions under the Privacy Act, the agency actually needs to publish notice that they're going to use that exemption in the SORN. And for that reason, knowing where to find the SORNs is very important, because that will, in some cases, determine whether or not you can release the information. So in processing requests, you're going to process first-party requests under the Privacy Act and then under the FOIA for the greatest amount of disclosure. This is because we don't want to limit someone's access by only looking at one statute. So whenever you receive a first-party request, you want to look at it under the Privacy Act and then also under the FOIA, because something may be exempt under the Privacy Act but not under the FOIA, and so we don't want to limit their access. Third-party requests are processed only under the FOIA. And so that would really just go right in line with what Bobby was talking about earlier and talking about all of the different exemptions that would apply. You treat a third-party request, even if it's for Privacy Act records, as you would any other FOIA request. So let's break down how to process a first-party request, or how they will be processed if you are not the one who actually processes them. First, you'll look to see whether or not a Privacy Act exemption applies. If no Privacy Act exemption applies, the information gets released to the first-party requester. You do not even move on to the FOIA analysis. So a great example of this actually are any records that fall within the OGE Gov-1 and -2 SORNs, because those do not have any Privacy Act exemption. So if you have a first-party request for those records, they will be released to that first party. And this is actually a great example of the dynamic between the FOIA and the Privacy Act and first and third party requesters, because if a third party came and requested that information, they probably wouldn't get it because of some of the Exemption 3 statutes, depending on specifically what they were asking for. And so that would be only looked at under FOIA because it would be a third party request. However, if you've got a first-party request and a Privacy Act exemption does apply, then you're not done yet. You have to continue on to the FOIA analysis and determine whether or not a FOIA exemption applies. If you cannot find a corresponding FOIA exemption, that information needs to be released. This is because if someone makes a Privacy Act request, the fact that they made a Privacy Act request shouldn't be the determining factor in whether or not they get the information. If they came back the next day and made a FOIA request and they would get that information, it just, those things don't really make sense. So whenever you have a first party request, whether or not they're specifying FOIA or Privacy Act, you really want to just look at both statutes and analyze under both statutes, because they're entitled to that will give them the greatest amount of access. So if no FOIA exemption applies, but there is a Privacy Act exemption, then you do need to release that information despite the Privacy Act exemption. However, if a Privacy Act exemption applies and a FOIA exemption applies, then you can withhold the record. Information can only be withheld when you have exemptions under the Privacy Act and the FOIA that apply. Now, when processing third-party requests, as I've mentioned, you process them only under the FOIA. And you release records if FOIA requires disclosure. FOIA requires disclosure if no FOIA exemption applies. So one slightly different aspect about processing Privacy Act records under the FOIA is that you cannot make discretionary releases of Privacy Act records. So as I mentioned, in many cases, Exemption 6 and 7C are going to cover the Privacy Act records. But in some cases, that may not be the case, or maybe you can segregate out certain information. But if there's another exemption, another FOIA exemption that maybe perhaps is discretionary, like an Exemption 5 deliberative process, information that's contained within the Privacy Act record, you cannot make a discretionary release of that information because of this language from the Privacy Act B2, which says that you release records if FOIA requires disclosure. So if Exemption 5 deliberative process can be applied, technically a FOIA exemption applies, and so you have to invoke it. And one last thing to remember is that when you have a third-party request, well, generally to release Privacy Act records, you need a request in hand in order to release the record. Generally, we're not going to see proactive disclosures of Privacy Act records, but once you have a request, you can go through and do the analysis and make the release if doing so is appropriate. All right, and with that, I think we'll turn it over to Jen, but here are some resources for OIP and our contact information in case you have any further questions after this presentation.
Great, thank you. I did something that Patrick taught me not to do, and I loaded these slides with a lot of information that I'm not necessarily going to go over every detail, but I wanted you to have it sort of in one place for future use. But I'm going to just touch on a few points. Before we do, I just wanted to clarify, I guess you can't clarify something that someone else said, but I wanted to make a note of something that Bobby had said. He mentioned that OGE Guidance would be something that would be disclosable, in fact, would most likely be required to be disclosed, which is, of course, we do not question that. But I did want to point out that OGE considers that communications between our desk officers and agency ethics officials, I don't know if you would use the term guidance for that. It would be more them seeking advice and assistance in how they would either advise their employees or take other actions. And OGE does consider those discussions with the desk officers to be deliberative, and we do frequently invoke Exemption 5 over that. So just in case that caused any confusion, I like to point that out because one of my pet peeves is when people are inhibited from taking down information or using information in certain ways because they're so fearful of the Freedom of Information Act. And so I like to clarify certain places where information is protected so that it doesn't inhibit. I wouldn't want people to be inhibited in contacting your desk officer and having that back and forth because of the fear that that would be released. The desk officers are not decision makers. They can't make official OGE guidance, so to speak, would be distinguished from our legal advisories or other such official OGE guidance. So just want to make that point. But anyway, so getting to disclosure under the Ethics in Government Act, this is the basic public financial disclosure provision. 105, it essentially limits the disclosure to the what we would call the Form 201 requirements. It's not very onerous. You need to give a few basic pieces of information, and then those reports are public, but they are, the requirements are there, and as such, this would be an Exemption 3 situation where you would turn to the Ethics in Government Act to file to require a Form 201 for that. And at the bottom, you'll note I also highlighted our regulation and the system of record notice that applies, as Lindsay pointed out. And OGE has 2 government-wide system of records notices, this one for the public financial disclosure reports and another one for the related records and another one for the confidential, and they're both available on our website in our Privacy Act FOIA section of our website. So this is the provision that talks about the disclosure, the 201 process. Just to note that you also can use a Form 201 to obtain completed Form 201s, and that the statute explicitly provides for that process. This is one of the things I definitely wanted to highlight. So there's generally a 6-year time limit on the public financial disclosure reports. These are the 2 relevant provisions. You can see the first one says it can only be made available to the public for 6 years, and the second one says it will be destroyed unless needed in an ongoing investigation after that time period. So what I like to say about this is that 2 wrongs don't make a right. These are 2 separate provisions. There's a requirement to destroy and also a limitation on when the report can be made available. So if for some reason the report has not been destroyed within the 6-year period, it doesn't mean you can now disclose it and release it. I point this out because it's contrary to the typical FOIA situation where even if a record could have been destroyed, if it hadn't, you still need to normally, if you would otherwise have to release it under the FOIA, you can't withhold it because you could have destroyed it. When we're dealing with these Ethics in Government Act provisions, that doesn't apply because again, we're dealing with Exemption 3. So even if you haven't complied with the requirement to destroy, you still cannot release it after the time frame has expired. I just put this up here that there are provisions in the Ethics in Government Act that allow agencies to require fees. We never charge fees for Ethics in Government Act disclosures or for our FOIA, really, because everything is done electronically and it just doesn't come up that fees are really incurred. But I just wanted you to know that those provisions do exist. So confidential financial disclosure, obviously the basic rule is that those records are confidential. And as Bobby explained, again, Exemption 3 would apply. I just wanted to point out here, and I quote our regulation on this point to make it explicit that there's no public access to these reports except pursuant to the order of a federal court or as otherwise provided under the Privacy Act. And I point that out because one question we often get is, can I show HR the confidential financial disclosure reports, or can I show the person's supervisor? And as Lindsay pointed out, there is a need to know within the agency condition within the Privacy Act. So of course, they can be shared within the agency, as Lindsay pointed out, to the point that it's needed to do one's job. So getting FOIA requests for financial disclosure reports, as Bobby said, courts have found that the Ethics in Government Act is an Exemption 3 statute, and we routinely withhold confidential financial disclosure reports pursuant to that. So if you get a FOIA request, Exemption 3 applies for both public and for public financial disclosure reports as well. But I did want to note that, as Bobby mentioned, we here at OGE don't want to be overly bureaucratic about it. If we can point them to the place on our website where they can obtain it after filling out electronic 201, We do that if they have emailed us the same information that would be on the 201, we go ahead and give it. So although it's important, in our mind, we want to comply with the Ethics in Government Act disclosure provisions. We don't want to be bureaucratic, and we do want to provide good customer service. And that's really the main points that I wanted to make sure to get across. And so I wanted to make sure to leave plenty of time in case folks had questions. Do we have any questions?
Are you ready to go to questions for the audio lines, ma'am?
Sure.
All right, thank you. If you do have a question, please press star followed by the number 1 on your touch-tone phone. You'll be prompted to record your first and last name. You do need to check that your phone is unmuted before you record your name. If you decide to withdraw your question, you can press star 2. Please give your parties a moment to queue up. Thank you.
And this is just a reminder that if you're on the Google Hangout, you can ask a question by typing it in the box in the lower right-hand corner of your screen.
No such thing as a bad question.
Once again, please press star followed by the number 1. Unmute your phone and record your name if you have a question or comment. So far, we have no one queuing up.
And I'm not showing any questions on the Google Hangout.
Oh, okay.
All right.
Well, then, thank you.
And that concludes today's presentation. Please join us next time for the Fundamental series.